Hello, Suppressor Nation. This is Michael Williams, General Counsel of the American Suppressor Association, and I want to give you the ASA's reaction to the recent filing by the acting U.S. Attorney down there in the Eastern District of Louisiana in the U.S. v. Peterson case, which I'm sure you have all heard of by now. So, as you probably know, the acting U.S. Attorney there filed a brief with the Fifth Circuit where he insists that suppressors are in fact not arms and therefore not covered by the Second Amendment. Obviously, we at ASA very much disagree with that take. And I want to give you a quote that he included in that reply that I think encapsulates the his lack of understanding here of suppressors and the current state of suppressor law in America. He says, quote, "Rather, it is Peterson's proposed test that would contravene the Supreme Court's Second Amendment jurisprudence. A pillow or a plastic soda bottle taped to the barrel of a firearm can also reduce the noise from the discharge of a bullet. Do these items too become weapons when attached to a gun and therefore gain constitutional protection?" The answer is yes. And we know that as suppressor owners, that ATF interprets the law, and the law is written in such a way that it allows for an interpretation where a soda can or a soda bottle attached to a firearm with an intent to suppress it, or even without the intent, with the effect of suppressing it, that counts as a suppressor. People have gone to jail for that. So he says it as an aside, but in fact, that's the law of the land. We agree that it's absurd as applied there, but we do think that therefore, when applied to a firearm, they are covered by the Second Amendment's protections. He goes on, and of course, not all suppressors are created equal. If a suppressor is protected by the Second Amendment because it is a useful attachment, how much noise does it need to reduce before it becomes useful enough? Well, again, suppressor owners, we know that the answer to that is any amount, and that's been ATF's longstanding interpretation of the Gun Control Act and the NFA. So it's a pretty easy bar, any amount. He goes on, how does a court measure a suppressor's utility against Congress's reasons for imposing a regulation? Does a suppressor need to effect greater noise reduction for less onerous regulation? Again, there he gives away the game when he says he's wondering about Congress's reasons for imposing a regulation. While what Congress thinks matters, obviously, in the judicial context and specifically in the Second Amendment context, it's irrelevant. The court has laid out a pretty specific test there in Bruin, and the question involved is the history and tradition of regulating firearms at the time of the founding and at the time of the ratification of the 14th Amendment. So, I'm just not sure he gets it. We disagree vehemently with this filing, and we are hopeful, very hopeful, that Maine Justice and Attorney General Bondi will take a look at this and hopefully be able to, seriously reconsider this position.